Well, we have reached the point where you get to be all grown up and become real estate agents, because now you are holding the most important document for most of you for the rest of your life. The offer to purchase and contract from the North Carolina Association of Realtors. For most of you, I would say 95% of your income from now till you go to your grave will be made on this document right here. At least it has been for me. And so it is an important thing. This chapter, sales contracts, is a super important chapter. It's going to be really heavily tested. Now, I know I say this a lot, but I have to revisit this one thing. This form does not come from the North Carolina Real Estate Commission. Are you going to see that language on the test?
Yes.
Yes. Is it put there specifically to mislead you? Yes, it is. This form does not come from the North Carolina Real Estate Commission because the North Carolina Real Estate Commission does not generate contract forms. They don't do that. That's not their job. Only attorneys that you hire to work for you can generate contracts for you to use. What attorneys have you hired who work for you if you use this form? The ones who are hired by the North Carolina Association of Realtors. One of the biggest benefits of being a member of the Association of Realtors is that you have access to a whole library of forms that have been drafted by attorneys specifically for use in North Carolina. So when we talk about in this chapter the rules of what things must be in a sales contract, those rules come from the Real Estate Commission. The Real Estate Commission does say what should be in here and what should not be in here, but the Commission doesn't create the form. It's created by the North Carolina Association of Realtors for use by their members. And again, why do we teach you this version of the form? Why would we use their version of an offer to purchase and contract? By far the most common. I read an article last week that said it was estimated last year in North Carolina that 98% of all residential properties sold were sold using this document. So, odds are, if you're buying a house, you're going to see this piece of paper, or these many pieces. By the way, I've been in the business a long time. When I got in the business, this was 4 pages. It's 13 pages now. I have a copy somewhere, I'd have to dig it up, that a friend gave me years ago of when it was 1 page. And he said they thought things had gotten out of control when it had to go to 1 page of legal paper because they couldn't fit it all on 1 page. But yes, it gets longer and longer every year, and that's the beauty of hiring attorneys to draft something. They get paid by the word, so they make it longer than it needs to be. But we are going to go through that document in detail. We're going to talk about the offer to purchase and contract and go through it in detail because it's going to be heavily tested. Before we specifically go through that form, we need to talk about some basics about contract law. No, you cannot have one.
No, I have.
You have one?
Yeah, I have a quick question about it.
Oh, you have a question? Yes, you can ask a question. You can't have paper, but you can ask a question. Excuse me.
When the North Carolina Association of Realtors produces this, and then if you become a member of that,
yep,
then you have access to this and all the other forms. You know, like I read on the bottom zip form, like that's we use that as well with our company. Is there other platforms that make this available? Like
there are. So the North Carolina Association of Realtors partners with zip forms.
Okay.
As a digital provider. So the Association of Realtors gives you the forms, but you would have to handwrite them. There has to be some software platform that allows you to fill them in and send them out for electronic signatures and all that sort of thing. And the preferred provider that the Association of Realtors has for that is zip forms. And so a zip forms membership is also included in your Association of Realtors dues. You can use these forms on any number of platforms. So like DocuSign, for example. DocuSign, you can use these forms, but you would have to manually upload the forms into DocuSign because they don't have a partnership with the North Carolina Association of Realtors the way zip forms. The nice thing about zip forms is, and I'm not advocating for them, I'm just saying this is the nice thing, they always have the most up-to-date version of the forms because they're tied into the Association of Realtors.
Right.
Whereas with DocuSign, you kind of have to pay attention to when the forms are updated and update your own forms.
As you go.
Exactly, because they're not tied directly in the way Zip Forms is.
Okay.
But there's other, paperless pipeline, dot loop. There's there's probably 10 different software providers out there that provide a way to work with these forms and fill them in and sign them. And any of them are allowed because as a realtor, you're allowed to use the forms. And so whatever software program you choose to use is up to you.
Gotcha. Okay. Thank you.
That was a long answer. Okay? So we want to talk about the basics of sales contracts in North Carolina, and then we want to talk about the specifics of this particular version of a sales contract. Remember that when we start going through the specifics of this particular version, those things aren't the law. They are just the way this particular contract is structured. So one of the things you have to be careful of on the exam is if they ask you a contract question, are they asking you a general contract question, or are they asking you a question specifically about this contract? And so here's how you'll know when that's the case. If you look down in the bottom right corner, just to the right of the equal housing logo, see where it has the form number there, that standard form 2-T? Does everybody see that? That's how they'll always refer to it on a test. They would say, according to the standard offer to purchase and contract, form 2-T, provided by the North Carolina Association of Realtors, blah, 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 blah. That's how you know it's a question that is specific to this contract. And this is the only contract that they will ask you specific questions about its structure. Any other contract questions would be just generic contract law questions. Okay? So make sure, just don't get thrown off when you see that 2-T moniker. That's just the form number. Every one of their forms has a certain number. Like if you look up if you pull out the exclusive right to sell, it has a different form number for it. They all have different numbers. Okay? So, we want to talk about the sales contract. The reason it is... You do not have slides? Gosh, y'all are the most needy class I have ever... Just because I knew Jim was going to ask. Thank you for reminding me. I thought I passed them out already. Yep. There you go. So, why is the sales contract important? This is important because this is the set of promises between the buyer and the seller. Now, one thing, I've talked too much this week when I pull out a stool. That never happened. I was here till 10 o'clock last night. One of the things you have to remember is that nothing is set in stone in a transaction unless it shows up where? In the sales contract. They love to try to mislead you on the test with things like fixtures, for example. Remember we talked about fixtures previously. We said they would, say that the seller had told the listing agent that they did not want the chandelier to convey, and the listing agent had listed it in the listing agreement as a fixture that would not convey. And then they go on to ask you a question about what happens if the transaction takes place and there's no mention of it in the sales contract. Well, does any of that telling the listing agent and putting it in the listing agreement have anything to do with the actual transaction? No. The transaction is going to be governed by the sales contract. And so we always want to make sure that everything that's included as far as promises in that transaction makes it into the sales contract. Again, we want to warn you about drafting language. There is a huge difference between filling in the blanks on something like this and writing contract language. You should never write contract language as a real estate broker. You're not allowed to do that. You will certainly, that's one of those things you should keep your radar up for on a test as well. Questions that refer to, or answer choices that refer to drafting language, writing language. That's not your job. Whose job is that when you talk about drafting language? That would be an attorney's job, not ours. Our job is to fill in the blanks on a pre-formatted contract. That's it. If we, and this is going to happen in your career. You're going to have times when you read this and you go, well, but I don't like the way that says. We need to change it. Sure, but who do you need to change it for you? You need an attorney. You're not allowed to make those changes. Now, your client, the buyer or the seller, they can make all the changes they want to because it's their contract. They shouldn't. It's not a good idea because they're probably not attorneys either and they don't know what they're doing, but they can legally do it. You can't. Even if you're doing what they say to do, even if they tell you the exact language and you just write it in for them, that is not allowed. That's considered drafting language, which is a practice of law. So don't do that. All right? And again, we're going to talk about that offer to purchase and contract. That's the one we're going to go over specifically. Just as a note here, you should only use this form if you're a realtor. If this form is used in a transaction, it should be a transaction that involves a realtor because those are the folks who have paid to use this form. And you can be sued by the North Carolina Association of Realtors if you use these forms and there's not a realtor involved in the transaction. I've never known them to actually do that, but they say it's possible. All right? So, let's talk about some of the rules that the Real Estate Commission has regarding contracts. Okay? We're going to talk about what the Commission says must be in there, but let's first talk about what can't be in there. And I would put a big star beside this slide in your notes. That second one right there. It says contract cannot include a provision concerning the payment of commission or disclaiming liability. So, the Real Estate Commission, though they don't draft this form, they set the rules up for it, and they have given us two huge no-nos when it comes to a sales contract. What's the first one, shockingly? You can't put what on a sales contract? Commission to the brokers. Why do you think that is? Why would the Real Estate Commission say a sales contract between the buyer and the seller can't include statements about the commission owed to the brokers? That's the perfect answer. Because the sales contract is between the buyer and the seller. The sales contract has nothing to do with the brokers. Does that make sense for everybody? So, you cannot ever, as a licensee, put your commission in the sales contract. Where should you put your commission? On what kind of documents? On a contract, but not a sales contract. Buyer agency agreement or listing agreement. Those agency agreements should specify what you're going to be paid in the transaction, not the sales contract. And this last one, or a liability disclaimer. That's a lawyer's way of saying, I can't be held responsible. How many of you have ever read a contract and you see like some statement about, you know, you can't sue, we're not held responsible, we make no warranty, or we have no liability? How many of you have ever seen that kind of language in contracts? Yes, absolutely. You see it all the time. The Real Estate Commission is telling you expressly, you can't put that in there about yourself. In other words, what do they say your clients always have the right to do? Sue you. Welcome to the real estate world. The Commission says explicitly, you can't put a statement in there that releases you from liability as a broker. It's just not allowed. It's not allowed. I had somebody ask me one time years ago, could my client put it in there? I'm like, they can put anything they want to in there, I presume, but the Real Estate Commission says you can't put it in there. The real question would be, why would your client put it in there? You know, why would they put it in a statement? I'm not going to sue you, I promise. You know, I don't know why they would, but if they did, then good on them. Okay? So, let's go through this particular sales contract and talk about some of the specific things that are entailed in this contract. Okay? You ready? So pull out the offer to purchase and contract, the standard form 2T. Obviously, we want to list all of the sellers here. Hopefully we also list all the buyers, but is it necessary to always list all the buyers here?
No.
No, it is not. especially in the case of people who are married. But is it necessary to list all the sellers?
Yes.
No question. All the sellers must be listed here. Preferably, you will also list their marital statuses here. You know, like for example, if someone is not married, that should be listed on the contract. You know, and you're not married, correct? Okay, so Annie Rangel, comma, unmarried. That is the correct way to list Annie's name on a contract. And if you have a husband and wife or a married couple, you simply put, you can list, you can say husband and wife, you can say, you know, Tom Smith and wife Mary Smith, you can say Mary Smith and husband Tom Smith, you can say Tom and Mary Smith, a married couple. All of those are acceptable, but it should specify their marital status. Why is that important? Who's it a signal for, do you think? Who's the deed, and who's going to be preparing the deed? The closing attorney, right? The closing attorney, at some point when they get their hands on this contract, they need to know the marital status of everybody involved here. And so it's really helpful if we go ahead and list that as part of that first section up there. Obviously, we want to put a detailed legal description of the property. And what kind of legal description are we most likely to put on here? The reference to a recorded plat map. That's the most likely one, right? Could we put a meets and bounds description? Yeah, we'd have to attach it as an addendum though, because the meets and bounds ain't gonna fit on this thing. I mean, but the most likely one, and the one that they've left you spaces for, is the reference to a previously recorded plat map. And that's what you see there where it says, you know, plat reference, lot number, block number of subdivision. That's what that section is for, the reference to a recorded plat. So let's talk about the stuff that matters, the money. Subparagraph D down there. This is where we get the money rolling. Line 1 is the purchase price. Yes, indeed, it does say payable in US dollars, and I have never felt the need to specify this before now, but I was asked a question yesterday in a CE class. Could this contract be used for somebody paying in Bitcoin? I hope I never get to that point, quite honestly. The answer is no, because what does it say clearly on this line? Payable in US dollars, all right? So if you want to pay in Bitcoin, use a different contract. I'm not saying you can't pay in Bitcoin, I'm just saying it can't happen on this contract. The second line down there, a due diligence fee. So let's talk about some contractual words that matter. Due diligence fee, and then look at the next line. Initial earnest money, what is that word? Deposit. Do you think that they just randomly chose to differ those words and call one a fee and one a deposit? It was intentionally done. And why was it intentionally done? What do you think fee connotates? What does that mean? Fees are non-refundable. That is correct. A due diligence fee is a non-refundable amount of money. And it says payable to who? Circle it, underline it, star it, highlight it. You're going to see it over and over and over. Who is the due diligence fee paid to? Directly to the seller. And when does it say it's paid to them? The effective date of the contract, folks, is going to be the day we go under contract. So this is, put it all together, fee. What does that word mean? This is a non-refundable amount of money paid to who? The seller, as soon as we do what? Go under contract. That is the definition of a due diligence fee right there. A non-refundable fee paid to the seller the moment we go under contract. What do you think you're paying the seller for? To hold the house. Hold it's one good way of looking at it. Take that to its next logical conclusion. If they're holding it, what are they not doing? Selling it to somebody else. Essentially, what you're doing with paying that due diligence fee is you're paying the seller to take the house off the market. Does that make sense for everybody? They lose the ability to, by accepting that fee, the seller no longer has the ability to market the property. Now, do you think there's going to be some time limitation attached to that?
Yeah.
Absolutely. We're going to get to that later on, and we're going to call that the due diligence period. That's the period of time that you're paying for with your due diligence fee. Is everybody okay with this idea so far? And it's what? Refundable or non-refundable? Non-refundable. Non-refundable money paid up front to the seller as soon as this contract is accepted. Everybody good with that definition? Now the next line, the earnest money deposit. The earnest money deposit. It says made payable and delivered to escrow agents. I want you to underline that. Where is the earnest money deposit going? To an escrow agent. Escrow and trust mean the same thing. So, this amount of money is not going to the seller, is it? It is not. It's going where? It's going to somebody into an escrow or trust account and being what? Held there. It's put in jail. It's being held. It's being held. It's not going directly to the seller. It is being held in a trust account. Why do you think it's being held in a trust account? What do you think the point is of an earnest money deposit? Why would a buyer pay? We understand that they pay a due diligence fee for the seller to pull the house on the market. What's the point of this earnest money deposit, do you think? Why is it there? What is it supposed to do? What does it accomplish? Shows the buyer's serious, absolutely.
But it's used as damages if the buyer backs out.
Perfect. It's used as damages, and we talked about damages the other day. Do you remember the name of a specific type of damages that I said would be really important later on in the class when we talked about this contract? The ones that we agreed to up front? Liquidated damages. The reason the earnest money deposit is so important is that it will serve as liquidated damages if for some reason the buyer does not do what? Does not close on the property. If for some reason the buyer doesn't close on this property and they breach the contract, then that buyer's earnest money deposit is going to be forfeited over to the seller, and it serves as what we call liquidated damages in the transaction. And what that means, we talked about what liquidated damages were. What do we say that means? They don't. The seller doesn't have to sue to get it, and even further than that, what? The seller can't sue. They're agreeing that this is all the money that they're going to be paid if, for some reason, the buyer breaches the contract. And we're going to talk about when that earnest money deposit might be refundable and when it might not be refundable. Because remember, the word deposit indicates that it could be what? Could be refundable at some point in time. And that's a big part of this contract. Okay? Is everybody good on the difference between a due diligence fee and an earnest money deposit?
Does it always have to have earnest money deposit?
That's a wonderful question. Do we always have to have an earnest money deposit? Well, they left us a blank line. And what goes on a blank line? A number, right? A number ranging from 0 to whatever number you want to put. So, is 0 a number that you could put on that line?
Yes.
As long as the buyer and the seller what? Agree. Would that be rather foolish for the seller, considering that their only protection that the buyer is going to close is what?
Money.
What money specifically? The earnest money. So could the seller accept a 0 earnest money deposit? Sure. Would it be wise on their part to accept a 0 earnest money deposit? You're essentially saying to the buyer, I really, really trust you. And I trust you so much that if you walk away from me on the day of closing, you owe me nothing. Because that's what 0 means on that line.
But then they have the right to sue.
They do not have the right to sue because they've agreed that $0 will be what?
Oh,
The liquidated damages.
oh,
So is your question, I'm sensing, is different than the question you actually asked. What you asked me was, does there have to be earnest money? What it seems you're trying to ask me is there a way that they can still sue and not have the earnest money be liquidated damages? Is that where you were going with that?
yeah.
Yes, but not using this contract, because this contract specifies that the earnest money is going to serve as what? Liquidated damages. And here's the reason I'm playing this out. This is exactly what you have to deal with in brokerage, because when that seller says to you, well, no, I want the ability to sue them, what do you have to say to that seller? We've got to get a different contract. And what's the only way you can get a different contract? Hire an attorney. And you send that seller to an attorney and they say, yes, for $3,000 we will draft you a sales contract using this transaction. And they're going to have to decide what's more important to them. Paying $3,000 for a different version of a contract, I'm just making up that number by the way, or going along with liquidated damages. What do you think their answer is going to be? Liquidated damages sounds okay all of a sudden. Does that make sense? But that's a perfect example, and the reason I point that out is, do you think that's the perfect opportunity that brokers get themselves in trouble?
Yes.
Yeah, because what do brokers have a tendency to want to do in a situation like that? Amend, change, draft, practice law without a license, start putting lines through stuff and writing words in. No, no, and no. Do not do that. That is practicing law. That's a perfect textbook example of how it happens, because your client takes exception to something in a standard contract. Guess why it's called a standard contract? It's meant to be left alone. It's meant to be used exactly as is. You don't modify it. Okay? How do we feel about that? Good? All right. So the other money lines on here don't matter as much. I do want to point out there's two different earnest money deposit lines. You've got the initial earnest money deposit line, and then there's an additional earnest money deposit line. The reason I point out the additional earnest money deposit line is there's a phrase in there that we talked about the other day that you ought to pay attention to. What does that say? Time being of the essence with regard to said date. So what does that mean about the date that would go on that line before that, in that blank? What does that mean about that date? It is set in stone. That means if you miss that date, you're in breach instantly. That's what it means when we say something's time is of the essence. When you miss a time is of the essence date, there's no grace period. You're in breach. Does everybody follow that? So if the buyer had promised to pay additional earnest, and why would a buyer do additional instead of initial? What do you think?
In case they want to
Get more time?
extend.
More time? Sure. How about they don't have the money right now? You know, maybe they don't have the money right now, but they're going to get their income tax refund in another 3 weeks. And so the seller has countered that they want a $5,000 earnest money deposit, and the buyer says, well, I can do $1,000 now and the other $4,000 in 3 weeks. Could we do the $1,000 as an initial earnest money deposit and the additional $4,000 as an additional earnest money deposit that would be due in 3 weeks, time being of the essence? Yep. Now, I wouldn't want to write 3 weeks on that line. What would I write on there? An actual date. I'd pull out a calendar. I get on my agents all the time about this in the past. They write 30 days. Stop being lazy. They got a calendar, look at today, and count 30 in front of that, and you write that date on there. Not 30 days. You write a date. Because 30 days is drafting language. That's the problem with it. Okay? All right. If you go all the way down to the bottom line, you get the balance of the purchase price due in cash at closing. This tends to be something that confuses people later on. When we get to closing statements and calculating closing statements, and we say, well, what does it mean that the buyer's going to pay the difference in cash? Folks, that's how they always pay the difference, in cash. You bring cash to closing for whatever amount of money your loan does not cover. Does that make sense? And so all this line indicates is, well, I'm paying this much right now as a I'm paying this much total for the property. I'm paying this much as a due diligence fee. I'm paying this much as an earnest money deposit. And here's the difference. Here's what I owe after all those things. So what does that tell you about the due diligence fee and the earnest money deposit as far as the purchase price. It is part of the purchase price. So when somebody asks me about losing their due diligence fee, my answer is that the only way you can lose a due diligence fee is if you do not do what? Close. Because if you close, clearly, it is simply part of the purchase price, as well as the earnest money is part of the purchase price. Does that make sense for everybody? That's why it says the balance due at closing. Okay? Flip over to page 2. We've got a whole paragraph up there about the earnest money deposit. I want to point out some things about the earnest money deposit in here. We've talked about them, but I want to point them out again. It says the initial earnest money deposit, the additional earnest money deposit, and any other earnest monies paid or required to be paid in connection with this transaction shall be deposited and held in escrow by the escrow agent until closing, at which time it will be credited to the buyer. Oh, and you might want to highlight at which time it will be credited to the buyer, because when we start doing closing statements, and I say the earnest money is a credit to the buyer, you'll know where that comes from. It comes straight from the sales contract. It says at which time it will be credited to the buyer, or until this contract is otherwise terminated. In the event that this offer is not accepted, then the earnest money shall do what? What happens if the offer is not accepted? It gets refunded to the buyer. Does everybody see that? Okay? So in the event it's not accepted, the earnest money shall be refunded to the buyer. In the event of a breach of this contract by the seller, the earnest money deposit shall be refunded to the buyer, but that doesn't affect any other remedies available to the buyer for such breach. What do you think that language means? The buyer can still what? Sue. If the seller breaches, the buyer can still sue, because it says it doesn't affect any other remedies available to the buyer. In the event of a breach of this contract by the buyer, the earnest money deposit shall be paid to the seller as what? Liquidated damages, and as the seller's sole and exclusive remedy for such a breach. What do you think sole and exclusive remedy means?
That's all.
That's it, that's all, and there ain't no more. So whatever number you put on those 2 lines for earnest money, you better be satisfied as the seller, because that's all you're going to get. Are we good on this idea of liquidated damages? Okay? It's a really important one. Alright? That's all I'm going to point out in that paragraph. The rest of it is not so necessary for you guys on the test. Okay? There is a big note on here, and you need to be aware of this note. Before we read this paragraph, and then we're going to read this section in the box here, let me tell you that contracts are imported in one place. We said this the other day, and where is that one place? In court. So all this language is not written for us. It's not written for the buyer. It's not written for the seller. Who's this written for? A judge. Hopefully, this document never ends up in front of a judge. Would you agree with that? But the language is there for a judge. Now, let's read this box right here. It says, in the event of a dispute between the seller and buyer over the earnest money deposit held in escrow, a real estate broker is required by state law to retain the earnest money deposit in escrow agent's trust account until they've either gotten a written release from the parties, so that would be the buyer and seller, right? Or until disbursement is ordered by a court. So, even though this contract tells us, I'm going to give you a scenario. The buyer breaches the contract. What does the contract say happens to the earnest money deposit? It goes where? Goes to the seller. That's what the contract says will happen. That's not what we do. It's not what we do. What do you think we do? We hold it until what? Until either they agree what will happen to it, or a judge tells me what to do with it, because that language saying that that earnest money will be forfeited to the seller Who's that language for? The judge. Now, are we going to try to convince the buyer to release that earnest money to the seller? Absolutely we are. Because if I represent that buyer, I'm going to look at them and say, now, you don't have to release this money. But it says right here in pretty dang clear language that in the event you breach the contract, which you just did, that earnest money belongs to who? The seller. And if you don't release it to them, what do you think they're going to do? They're going to sue you, and they're going to win. And not only are they going to win the earnest money, but then they're going to win their court costs, their attorney's fees, and it's going to end up costing you a bunch more money. But if that buyer ultimately doesn't agree to release that money, what does the escrow agent do with it? Hold it until either the parties agree or a court of law tells you what to do with it. Is everybody good on that? That's what I mean when I say this language is not for us. It's important to us, but the language is ultimately there for a court of law. Okay, are we all right with that?
Is there like a statutory period if the seller doesn't sue and the buyer just won't? It can just be held there for X amount of years?
It can be held forever. In fact, it used to have to be held forever. There were brokers in North Carolina who had earnest money deposits from 30, 40 years before. And which is the most frustrating thing in the world because you can't use the money either, you know. So you just basically have to keep balancing money that's not yours that sits in the trust account. Several years ago, the state legislature passed a law which allows us, after a certain amount of time, to turn it over to the state. Imagine that. They gave us permission to give it to them. Which was actually a relief to the brokers who were holding it because they didn't want it. It wasn't useful to them. So what happens now is, if it's been a year, say it's been a year, and you've got a dispute. You know, the seller wants the earnest money, the buyer wants it refunded. That's what a dispute is, right? They both think they should get it. You can't release it. And you have to wait for them to either come to an agreement or one has to do what to the other? Somebody's got to sue the other. Well, let's say it's $500. This happens a lot. $500, even the one who feels like it belongs to them is probably not going to take the time to go down to the county courthouse, file a small claims action, which costs like $400 to file, and then have to go to court. Now, of course, when they win, they're not only getting the $500, but they're also going to get the $400 filing fee, but they got to spend 3 days dealing with the courthouse, and so what do? They just say, the hell with it, I'm not doing it, right? And so the money sits in the trust account. Well, after a period of time, let's say a year later, the broker who's holding that in their trust account can send a letter to those two parties and say, I'm sending this money to the clerk of court. Y'all can deal with them. And when it gets to the clerk of court, then the clerk of court will send a letter to the two parties saying, we've been placed in custody of this money, and you got 30 days to come to an agreement, or it belongs to the state of North Carolina. So basically, after a period of time, we're allowed to release it.
And if it is that small and the seller just says whatever, you back to the buyer, that's fine, even though that goes against what the contract says?
That's exactly right. Did everybody hear the question? You know, if it's a small amount of money and the seller's like, well, I'm not suing over it, and they want to just release it back to the buyer, even though the contract says it belongs to the seller, they can, of course, do that. And often, what ends up happening with disputed monies is, what I used to do when I would have disputed funds is I would go to the seller and I would say, listen, the contract says you are owed all the money. Clearly, you have no desire to go sue them for it. So why don't you let me offer to refund half of it to them? Because I think if we offer to give them half of it back, they would be agreeable to that, and you getting half of it is better than you getting none of it. Does that make sense for everybody? And it's better for me because I got it out of my dang trust account, which I did not want it sitting in there anyway, because it's just a pain to have to deal with it sitting in there. So everybody okay with, you know? So you can come to whatever resolution is okay with them is fine. That's what I mean by the contract language is only there for a court of law. That's only going to matter if it ends up in court. Now on a test, when they ask you what happens with the earnest money, you're going to go with what the language says. Does that make sense? The only time you would worry about what we just talked about is if they make a point of saying the funds are in what? Dispute. The funds are in dispute. If the funds are in dispute, then you hold them. Yeah.
Who's generally the escrow agent? Isn't it generally like a hired attorney or?
That's actually going to be one of the next points I was going to talk about. So that's perfect timing on the question. Who is generally the escrow agent? Most likely, and you ought to put this in your notes because it could potentially show up on a test. Traditionally, the most common example of an escrow agent was the group of people who was looking out for the best interest of the seller. Who would that be? The listing firm. That is the most common traditional escrow agent. Because if you were the seller, who do I trust more than my own agent to hold this money in trust? So the listing firm has traditionally been the source of the trust fund that would hold the earnest money deposit. Now, in today's world, that is slowly but surely changing, because most real estate brokers have come to realize they can get away with not having a trust account if they don't hold earnest money deposits. And so it takes a whole layer of responsibility away from us as real estate brokers to not have a trust account. It doesn't have to be the listing firm. It can be anybody that the buyer and the seller agree on. Who do you think is the next most likely that the buyer and the seller would agree on? The closing attorney. And ultimately, that's where all the money ends up anyway, so it seems to me to be the most logical choice of a place to hold it. Have the closing attorney hold the earnest money deposit. And so that's generally what I do when I represent a buyer or a seller, is use the closing attorney as the escrow agent. Does that make sense? But it's anybody that the buyer and the seller agree on. That's why there's a line here to write who the escrow agent's going to be, because it's negotiable. Yep.
In the example, like so the earnest money gets paid and then they agree to split it half and half, like half gets refunded.
Mm-hmm.
Does that need to be in writing, that agreement, or can it just be oral? So
It needs to be in writing.
Okay.
It needs to be in writing. And as a matter of fact, in the forms available from the Association of Realtors, there are two different versions of the contract termination form. There's an agreement to terminate the contract with the release of the earnest money, and there's an agreement to terminate the contract and the earnest money is still in dispute. So if they fill out the one that says that they're releasing the earnest money, there's a space on there for them to detail how the money's going to be released. Is it all going to be turned over to the seller? Is it all going to be refunded to the buyer? Or is there going to be some other split of the money? But yeah, it needs to be in writing.
Okay.
Just to protect the escrow agent. Okay, everybody good with this idea? We understand what the escrow agent is and who it's most likely to be. Most likely sources are either the listing firm or the closing attorney. Good, good. All right. There is a statement on here that says that it can be placed in an interest-bearing trust account. You do not need their permission to place it in an interest-bearing trust account. It's just a statement that says the trust account can earn interest. I never did when I managed a trust account, and here's the reason why. Remember, I can't keep any mixture of my own money in the same account as my client's money, right? That's the whole purpose of a trust account. So every month, when that interest payment was deposited to that account, what did I have to do with it? I'd have to remove it out. All 18 cents of it had to come out, and I had to create a ledger entry for that 18 cents being paid in, and another ledger entry for that, and I had to write a check to myself for 18 cents. No, I'm not doing that, you know. Now, if I was managing a commercial property management account where there was $10 million sitting in my trust account, would it be worthwhile to have that be interest bearing?
Yes.
Yes, and they do. But most small residential trust accounts, it's just not worth it because there's not enough of a balance in there for it to matter on a monthly basis. Okay? It says the effective date is the date the last one of the buyer and seller has signed, and that is communicated to the party making the offer or counteroffer. Remember, we say that we go under contract when we have communication of the acceptance between the two parties, right? Not just when they've signed, but when we've communicated that acceptance. That's the effective date of the contract. It talks about what the due diligence fee is. We've already said that that's a negotiated amount paid by the buyer to the seller with the contract. And it is what? Refundable or non-refundable? Non-refundable. So let's talk about the due diligence period. It says the due diligence period is the period beginning on the effective date, and we said the effective date is when?
The time that they,
Both parties.
Both parties sign and we communicate that acceptance. So basically, it's when we go under contract, right? So the due diligence period begins as soon as we go under contract, and it ends on this date that we're going to fill in here on this line. We call that the due diligence expiration date. And notice it says what behind that date? Time being of the essence. And on this one, it gets real specific. Not only does it give us a date, what does it say? 5 p.m. I did have somebody ask me, what time zone? What state is this contract used in, folks? Last time I checked, we are in the Eastern time zone. The next thing somebody will ask me, is that daylight saving time or not daylight saving time? 5 p.m. Eastern Standard Time. Time being of the essence on that date. So, we need to talk about why that date's important. While we're here, and we're talking about the date, let's talk about why the date's important, because this is going to be on the test. You're going to see this. Something changes dramatically on this due diligence date. Dramatically changes. Turn over, I'm going to skip ahead for just a second. Turn over to page, due diligence process, page 5, subparagraph F. It's in the middle of the page. It says buyer's right to terminate. Does everybody see where I am? Buyer's right to terminate. Buyer shall have the right to terminate this contract, and it gets really specific and tells you the reasons why the buyer can terminate. What reason can the buyer terminate? For any reason or no reason. They have bad gas that day, so they're terminating the contract. Is that any reason?
yeah.
Yes. For any reason or no reason, the buyer can terminate this contract. I point that out to you because agents don't understand this. They feel like the buyer has to have some reason to terminate. They don't, folks. It says right here the buyer can terminate for any reason or no reason, simply by delivering the seller written notification. But only during what time period?
Due diligence period.
The due diligence period. Time being of the essence. And if they timely deliver that termination notice, the contract shall be terminated, and highlight that last part. And the earnest money deposit shall be refunded to who? The buyer. But only if they terminate during what period of time? The due diligence period. So what do you think that means if they terminate after the due diligence period? They lose what money? The earnest money. The due diligence fee is already gone. That's non-refundable. That's not coming back. But that earnest money deposit is refundable for a certain amount of time. Now we know what that amount of time is. What is it? The due diligence period. So if I ask you one simple question, what changes on the due diligence date? What would you say? The earnest money becomes non-refundable. For what reason?
Any reason.
Any reason. That's how crystal clear this contract is. The buyer has the unilateral right to walk away for any reason up to the due diligence expiration, and they will get what back? Their earnest money. They have no right for any reason to walk away after the due diligence expiration, and if they do, they will have a penalty, which will be what? The earnest money deposit as liquidated damages. This contract is meant to leave no room for interpretation. Does that make sense to you guys? Everybody is supposed to understand clearly what will happen based on what plays out in the contract. Obviously, if we close, great. The buyer's going to get credit for their earnest money deposit, they're going to get credit for their due diligence fee, and we're done. Does that make sense? If we don't close, we're simply going to look at when notice was given. And if it was given before the due diligence period expired, we're going to do what with the earnest money? Refund it to the buyer. If notice came after the due diligence period, does it matter what reason the notice was for? No. If notice came after the due diligence period, we're going to do what with the earnest money deposit? We're going to forfeit it to the seller as liquidated damages. That's the way this contract's structured. That's what you need to know on a test about it. That's the way the questions are going to ask you. It's going to ask you, this is what's happened. What do we do with the earnest money deposit? Okay? Is everybody good with that? Don't let them talk you out of it. Does it matter why the buyer's terminating? No. The whole point of the due diligence. So, now, let me ask you a more practical question. Now knowing what you know about a due diligence fee and a due diligence period, is it important that the buyer negotiate enough time to be really sure that they want to move forward with this transaction?
Yes.
Yeah.
Yeah, so what kinds of things might they need to get accomplished during the due diligence period? Inspections. What else? Appraisals. How about getting final loan approval?
Yeah.
Because they were just pre-qualified when they made this offer, right? Is it important to know for sure that the lender's going to make this loan? Right? We want to go ahead and submit the loan to underwriting and get a final loan approval before this due diligence date, right? We want to do everything. If they want to do a septic inspection, do it during the due diligence period. If they want to ask the seller to make repairs, when should they make that request?
Within that period.
Before the due diligence period. Because does the seller have any motivation to do anything for you after the due diligence is over? No. At that point, they're doing it out of the goodness of their heart, which, like the Grinch, like 12 sizes too small, right? It's not going to happen. So as a buyer's agent, this due diligence date is extremely important. Here's one of the things I always laugh at about brokers in our business. They get that. They understand as a buyer's agent, oh, I should get the appraisal done during the due diligence period. Here's the part of it they don't get. That's your problem, not the seller's. Because here's what's going to happen. And it's going to happen to you, whether you're on the buyer side or the seller side, it's going to happen. The buyer doesn't go pay for the appraisal. And you get a week out from your due diligence date and you just realize, oh shit, we haven't done the appraisal. Guess what? It ain't going to happen in a week. You're not going to get that appraisal report back in a week. So now, what does the buyer's agent feel like they need? An extension. Can you ask for an extension?
Yeah.
Sure. As a seller, do you have any motivation whatsoever to give an extension of the due diligence date?
For a small fee.
Give me that motivation one more time.
For a small fee.
Yes, I will be glad to grant you an extension of your due diligence date. For more due diligence what? Money. Because what you're extending is the buyer's right to do what?
Sell the property owner?
To walk away. The heck would you as a seller want to give the buyer more time
Yeah.
to do the one thing you don't want them to do, which is walk away? You know what my generic answer to somebody asking for a due diligence extension is? No.
No.
Pretty simple answer. No. Mm-mm. Mm-mm. And then I say, but we really need it. Okay, well then let's talk about how badly you need it. Just how badly do you need that extension? Is it worth another $1,000 to you? No. Then no. Because at that point, what do they have to make a decision about?
Sacrificing the due diligence.
Do they want to just walk away and blow the whole thing up, or do they want to let... And here's my favorite one. Well, we're not going to terminate the contract, but we need to get an extension of the due diligence just so we can get our appraisal done. Can you get your appraisal done after the due diligence period? Sure. Don't tell me we're not going to terminate and at the same time say, but we need an extension of our due diligence, right? That's like saying, put your hand on the table. No, that hammer's not any for you. Just don't look. I promise I'm not going to hit you with that. Well, then why you got the damn hammer, right? You don't trust anybody doing that. Don't trust anybody saying they need an extension of the due diligence period and at the same time saying, but we're not going to terminate. Then why are you asking for it? Because what's the only reason you have the due diligence period? In order to do what? To walk away. See, right there, you know more than 90% of the brokers practicing real estate right now. Because they don't think about it in those terms. They I call them the robot agent. You know, they get so caught up in, well, my appraisal's supposed to happen during the due diligence period. It didn't. Oh, well, I guess I better ask for an extension. No. How about do a better job of getting the stuff done during the original due diligence period? Does that make sense for you? So as a buyer's agent, as soon as you go under contract, you kind of have a laundry list of things that need to get accomplished. Better yet, should you talk to all these people before you even make an offer and know how long it's going to take you to get your inspections done, your appraisals done? Ask the lender, what date do you expect to have final loan approval? And then take those dates and look at them and say, okay, we need this much time for due diligence. Is that a better way to handle it?
Yeah.
Yep.
Yes, absolutely. That's how you protect your client. So if I'm the buyer, I want as long as possible for the due diligence period. If I'm the seller, I want what?
Shorter.
Tomorrow would be good for me.
5 o'clock.
If you're in a competitive market, you're trying to make your offer stand out, would a shorter due diligence period improve the appearance of your offer? Sure it would, because that's less time the seller has to worry about you backing out. Everybody good with this idea? Okay, good, good. Because you're going to see test questions about that. Back to page 2. Look at the last line on page 2, the settlement date. It says the parties agree that settlement, now settlement is generally synonymous with closing. Why do you think we've called it settlement and not closing? What do you think closing actually is? Closing is when we do what? We transfer title. And when does that happen? When we record the documents at the county courthouse, right? Is settlement going to happen at the county courthouse?
No.
Settlement's going to happen at where? The closing attorney's office, right? So settlement's when everybody signs the documents. Closing is when the documents get recorded. Could that conceivably happen on 2 different days? Especially if you have settlement really late in the day, right? If you have a 4 o'clock settlement meeting, those documents are not getting recorded till the following day. Because by the time you get done signing them, nobody has time to get to the courthouse to do what with them? To record them. Does that make sense for everybody? So that's why we call it settlement rather than closing. When is ownership actually transferred? At settlement or at closing? At closing, when it's recorded. When do we get paid? At settlement or at closing?
Settlement. No?
Closing. So here's what that translates to. Are you going to walk out of that attorney's office with a check?
No.
Nope. Get ready to go back. Because you're going to have to go back after the documents are recorded. Is the buyer going to walk away from that attorney's office with keys?
No.
No, because they don't own the house yet. They feel like they own the house. They just wrote a really big check. They just signed 6,000 pages worth of documents, but they don't yet own the house until what has happened with all those documents. They have been recorded at the county courthouse. It is actually against the law in North Carolina to turn those keys over to that buyer until those documents are recorded. Now, I have usually taken myself out of that consideration. Here's what I do. And it's dirty pool, I get it. The attorneys don't like it. When I walk in there, and I'm the listing agent, because this creates a problem, right? As the listing agent, do I want to have to come back and bring back a set of keys?
No.
No. Nor do I want to hand them to the buyer because they'd be breaking the law, right? So here's what I do. I come in and I hand them to the closing attorney. And I say, you are now entrusted with the keys. When you have recorded the documents, you may feel free to release them to your client, the buyer. Now, can I control if they give the keys to the buyer as soon as I walk out of the room?
No.
Do I really care?
No.
Nope. Because it ain't my responsibility anymore.
I like
But
that.
don't you hand them to the buyer. Does that make sense? You hand them to the closing attorney.
What if the
Let them
seller,
deal with it.
what if the seller's there and you know, the seller generally has to sign a couple documents at the beginning? What if they pass them on to the buyer?
If they pass them on to the buyer, I would look at my client, the seller, and say, now, I understand why you want to do that. It's fun to give somebody the keys. But recognize you still own the property. It's still your insurance on the property. You just gave somebody keys to your house. Even if it's only for 2 hours, you just gave somebody keys to your house. Generally speaking, though, I don't allow my sellers to be at the closing. And I've learned that the hard way through experience. Sometimes you don't realize that the seller may have some animosity built up toward the buyer or vice versa. You know, maybe some part of the negotiation was more contentious than you really thought it was. You know, like to you it seemed to go smoothly the whole time. What you don't realize is as soon as you got off the phone with them, they're like, son of a bitch, you know, and they're just mad because they feel like they've been taken advantage of. I have seen sellers and buyers at each other's throats at the closing table. Like somebody says one wrong thing, and because it's an emotional thing, letting go of a house and buying a house, and somebody says something that sets the other one off, and they're off to the races. So what I always say to my sellers is, you don't even have to worry about going to closing. I'm going to get all the documents ahead of time, and we can sit down and you can sign them, and we will get them notarized, and you'll give me power of attorney to sign the closing document for you so that you don't even have to show up.
And there's a document to get power of attorney.
There's a document to get power of attorney because I'm going to ask the closing attorney to draft one for me, to give me power of attorney to sign on behalf of the seller. And the reason I do that is to, I'm not saying to the seller, I don't want you there, but my undertone meaning is, I'd really rather you not be there. And I also look at it that way, it's the buyer's day, right? It's not the seller's day. This is not, I mean, this is for the buyer. Let them be comfortable. Is the buyer going to be more comfortable if the seller's not there so that they can ask questions and don't have to worry about, you know, the stress of the transfer? Because quite honestly, I don't even stay around as a listing broker. I go in, I ask the attorney what documents need to be signed on behalf of the seller. As soon as we sign those, I stand up, I shake everybody's hand, I congratulate the buyer, I hand the keys to the closing attorney, I say I appreciate everybody, it's been a great transaction, please enjoy your new house, and I am out. Let them stay for another hour and sign all those loan documents. That's not part of my deal. Now, if I'm on the buyer's side, of course I'm going to stay the entire time because I'm there to represent the buyer. Does that kind of make sense? I think closings go much more smoothly when you only have one party there. And the closing attorneys appreciate it too. They'd much rather not have everybody. Most closing attorneys' conference rooms, quite honestly, at this point, won't accommodate everybody being there. I mean, they've gotten like, you know, closing attorneys used to have these big, grand, now it's like a closet. You know, and there's basically room for like 4 people to sit at a table, and that's it. A lot of times as a listing agent, you're standing in a corner like, where do I need to sign? Okay. Reaching across, trying to do it. So, but yeah, I think you're better off, better served to not have all the parties there.
I just ask because it's just interesting to see, you know, the few that I've been around that some like bad practices, I guess you could call it. You know, so, because I've seen it happen more than once.
Keys handed over, of course.
You
Yep,
know,
absolutely.
direct by the wrong people.
Yep, it happens.
So.
Well, I mean, I've seen it. I would be lying if I didn't say that I've seen, when I'm a buyer's agent, I'll usually say to the listing agent, can you leave the lockbox on the house so that we can do our walkthrough right before closing? Because you'd like to do your walkthrough immediately before the closing, because what if the property's been damaged? You know, you want to see the property as close to going to sign those documents as you possibly can. So I usually do it right before, and then we leave from the walkthrough and go to the closing attorney's office. And what I'll ask the listing agent to do is, can you leave your lockbox on the door with the key in it so that we can get in? And I'll take the lockbox off and bring the lockbox and the key with me to closing. Well, I've had plenty of listing agents say, that's fine, just go ahead and give your buyer the key. No. Even as the buyer's agent, you know what I do? I hand it to the closing attorney when I walk in the door, and I say to them, here's the key, I'll let you handle that. And they know what I mean.
Yeah.
They know. They understand. And you know what most of them do, quite honestly?
Probably hand it over.
They give it to the buyer. But that's them doing it. That's them taking that liability, that responsibility. It's not Travis taking on that responsibility. Because as far as I know, the law says I'm not supposed to do it until those documents are recorded. So I just hand it over to the attorney. And honestly, it is the most responsible thing to give it to them anyway, because they're the responsible party at that point in time. They're the ones in charge of recording the documents. They're the one, you know, so they have the best feel on whether everything's going to go smoothly from that point forward. So most of them hand it over because they're very comfortable that as soon as they walk out of that room, they're going to record the documents and it's going to be over. So that, you know, I let them handle it. I think that's the best course of action. Yes, ma'am. Sam.
Who hired a closing attorney?
Who hires the closing attorney? The buyer does. The buyer does. Now, 9 times out of 10, or maybe even 99 times out of 100, my buyers have no idea who they would like to use as a closing attorney. So ultimately, they're going to rely on, in most cases, a recommendation from me of who to use as a closing attorney. But it is the buyer hiring the closing attorney.
Can the seller have one too?
The seller can indeed have their own attorney. Most sellers choose not to because there's quite honestly not much of a function on a residential closing for a seller to have a separate attorney involved. And so most of them choose not to because of the cost involved with it. Even drawing up the deed, which is a seller function, you know, the seller has to prepare the deed and bring it to closing. Most sellers end up employing the buyer's closing attorney to do that because it's just cheaper.
Oh, so they don't have to pay it.
I'm sorry?
So, no, so the seller don't have to pay much of money to the closing attorney.
Correct. The seller
So
may...
the closing attorney basically work for both.
No, the closing attorney works for the buyer. The closing attorney works for the buyer, but they will draft the deed on behalf of the seller if the seller asks them to. Usually for $150 or so. And most sellers don't care at that point, and so they're happy to pay the buyer's closing attorney to draft the deed. But if they're concerned and they'd like to have separate representation, they can certainly hire an attorney. There are plenty of attorneys who would be glad to sit at that table for them and charge money.
And the file for the deed, isn't that like e-file now? So it's like an instant?
In some counties it is. In some counties allow electronic filing. Wake County is one of those. But just because the county allows electronic filing does not mean the attorney participates in electronic filing. There's some cost involved. It's not, they can't go to Staples and buy a scanner and now they can e-file deeds. It doesn't work that way. They have to have a certain machine to scan those documents and a secure connection. They have to set up a secure connection with the county courthouse, with the clerk of court, and they have to pay a fee to do all that. Most of the big closing attorneys have done that, because it's a lot easier than having to physically go to the courthouse.
Yeah.
But in the there's 100 counties in North Carolina, and I think only like 7 or 8 of them offer electronic filing. The other 93, somebody still got to drive to the courthouse and record those documents.
But if you're e-file, then means it's recorded right away, right?
That is correct. If
So
they're
you can get
e-file,
a key that the same day and you can get the check too.
well, even when they are recorded in person, you're almost always going to have keys and checks available same day. I mean, the goal is always going to be to have recording be the same day, but it might be several hours later.
Yeah, but you said if it's 4 o'clock, then you couldn't.
If it's 4 o'clock, you're not going to get recorded even if it is e-file, unless it's a cash transaction. Because when the attorney leaves the room, before they can record any documents, they have to send all the loan documents the buyer just signed to the lender. And the lender has to look at them and make sure they approve, because they're not going to release the funds
Yeah.
to the closing attorney until they see the document signed. Does that make sense for everybody? So the process is going to be usually closing attorney sits down, signs all the documents, notarizes everything, and then they leave the room, take the documents, upload them all to the lender. The lender is going to certify the documents, and that takes half hour to an hour in most cases. And once the lender approves the documents, then it's ready to record. So even in an e-file case, it usually takes 45 minutes to an hour after the documents are signed till you'll be recorded.
Oh. So you say if it's cash, then it's done right away.
If it's cash, there's no lender to approve of them.
Yeah,
right.
so it's just
It's instant.
as soon as he e-file is done.
That's it. That's exactly
Oh.
right.
Alright.
So with cash, they'll usually walk out of the room, e-file, and come back and say, we're recorded.
Alright.
The loans slow everything down.
Oh.
And then you can imagine why. I mean, the lender's got a big interest in that thing. They want to make sure the documents are recorded correct or are correct before they release hundreds of thousands of dollars. With the exception of State Employees Credit Union. State Employees Credit Union, bless their hearts, I love them. They still send a paper check for the loan. And they send it like 2 weeks before closing. Like it just randomly shows up at the closing attorney's office. Here's a check for $400,000, and they have to. And so the closing attorney will come in with it like paper clip to the file, a paper check. Everybody else wires money. They still send paper checks out. They're great to work with. It's like the most old-fashioned, laid-back operation in the world. You know, it's great. You appreciate them when you turn around and deal with Bank of America the next day. You know, like. State employees, it's like 20 pieces of paper that need to be signed. Bank of America, it's like a ream of paper like this big, you know, and you're there for 2 hours signing. And eventually the buyer will look at you and go, didn't I sign that? Yeah, you signed it 3 times already, but here's a different copy of it you got to sign, because they're Bank of America. They need more paper. All right. Let's run through a couple of other things in this contract that we need to point out. Fixtures on page 3, just like on the listing agreement we talked about the other day, they've specified a bunch of things which are going to be considered fixtures. So if you have any question about if something's a fixture or not, the first place to look, if you're using this contract, would be at the contract itself and what is specified as a fixture. And it's a pretty extensive list. I mean, there are plenty of things on here that ordinarily would not be a fixture based on the law. Like, for example, the garage door remotes. Would that normally be considered a fixture?
Yes.
The remote?
No, the remote.
Not the opener, the remote. How do we normally consider something a fixture? What's the first characteristic? Is it what? Permanently attached. Is the remote permanently attached?
No.
To my visor in my car, maybe, but not to the house, not to the land, right? But this contract specifies it's going to be considered a fixture. So, because this is the contract you're using, you want to always look at it and make sure, like for example, your dog collars, if you've got an underground fence, they're fixtures in here, because it says invisible fencing with power supply, controls, and receivers. Receiver is the collar. So if you have underground dog fence, your dog's collar just became a fixture.
So if you're excluding items, I know you list them in D. That's not much room. Would you like attach them to a paper?
Yeah, right. If you were excluding a bunch more items, you would have to have an addendum, a separate addendum, and guess what you'd need? An attorney would have to draft it. If it doesn't fit there, you're going to have an attorney draft it. And they have specifically left these very small things because they don't want you drafting a whole bunch of stuff.
Should you also cross them out on here just so you're not like having to?
No, that's why an attorney would draft an addendum, because it would have language that says this addendum supersedes any language in this paragraph, and see, that's the stuff we can't do. And that's exactly why they don't want us doing it, because we wouldn't be smart enough to say this language is not valid and this language replaces it, and you know, that sort of thing. Paragraph 3 over on page 4, personal property. So this would be where you would list things that are not fixtures but are going to be what? Conveyed or included in the sale. So these are things, and notice it says they're going to be transferred to the buyer at no value. We don't need to talk about the due diligence process. We've already talked about that. Over on page 5, people say, oh, well, this house is being sold as is. Well, duh, they all are. Look at paragraph C on page 5. It's in all caps. The property is being sold in its what? Current condition. That is as is. That's what that means.
And that's why you want to do a walk.
Exactly, because once you've closed, it's yours in whatever that condition is. Alright? The only time you've got an argument as far as that is if the condition of the property has changed from the time of offer to closing. That has to be fixed. Paragraph 5, buyer representations for the loan and that sort of a thing. These are not conditions or contingencies. Let's talk about a contingency. You may see test questions about a contingency. What do you think a contingency is?
Something else has to be done before.
A condition. One thing has to happen before what? What's the big gotcha? Before I'm forced to close. The whole point of a contingency is a way to get out of a contract. You put a contingency in because you're worried that you might not be able to close. So why would I put a finance contingency in a contract? If I don't get the loan, I don't have to do what? Close. I'm not held liable for this contract. And more importantly, if I've put down something like earnest money and I don't get the loan, what's going to happen to my earnest money deposit? It's going to be refunded if that's a finance contingency. Is everybody with me? You need to pay attention here. If there's a finance contingency and I don't get the loan, what's going to happen to any deposits I've made? they'll come back. Because the contingency is protecting me. Does that make sense? If there's an appraisal contingency and the property doesn't appraise, what would happen with any of my deposits? They would be refunded. That's generic contract law. That is not this contract. This contract has 0 contingencies in it. It does not say here that this is a finance contingency. Does this contract have contingencies in it? It does not. None. You know why? We talked about it earlier. This contract's very clear. Why can the buyer get out of this contract and get their earnest money back? For any reason. Why the hell would they need a contingency, folks? A contingency is a way to do what? Get out of the contract. It already says they can terminate it for any reason. You don't need any contingencies in that. So, you need to be able to answer contingency questions for generic contract law, but you need to know that this contract has what? No contingencies. In this contract, if you don't get the loan, the only thing that matters is if you tell somebody what? Before the due diligence date or after. Because if you tell them you didn't get the loan before the due diligence date, what's going to happen with your earnest money? You can get it back. If you tell them you didn't get the loan after the due diligence date, what's going to happen with your earnest money? It's forfeited to the seller. Very clear contract. And the reason we did this contract was to eliminate contingencies, because contingencies get very murky. They sound great. Most people would be happy to accept a contract as a seller that says, if the buyer can't get a loan, they don't have to buy my house. Because every seller's like, well, that's reasonable. If they can't get the loan, they can't buy the house. How are you going to prove you couldn't get the loan? What proof do you provide that you can't get a loan? A letter from a lender, right? Your lender. The one you're working with. The one that represents you. Do you think your lender that you're working with, that represents you and is trying to keep your business, would be willing to write you a letter that says, Travis can't get this loan? Whether that's true or not, how the hell is the seller going to check? You see why a finance contingency could be a real problem? That's why we tried to eliminate them with this contract. But for your purposes, you need to be able to recognize contingencies on a test, because if they talk about contingencies, the contingency is a right to get out of a contract and get what back? All your deposits. All your deposits. Everybody okay with that?
Yes.
Right? So this is not a finance contingency in this section, it's just reference. This is how the buyer intends to pay for the property. Over on page 6, the questions about the disclosure statements. Remember, I said they have to tell you whether or not they've seen a copy of the residential property disclosure statement before they made this offer. So you see where it's got the options here. The buyer has received a copy, or the buyer has not received a copy. And it goes on to say, if the buyer hasn't received a copy, what are they going to get? 3 days to do what? To back out of any contract. Or the third one would be, the property is exempt from the Residential Property Disclosure Act. So what kinds of properties did we talk about that would be exempt? You might want to fill these in here.
New construction,
New construction. What else? Another big one.
foreclosure.
Foreclosures. Estate sales are also exempt, but the two big ones are foreclosures and new construction. Let's see, what else you need to talk about here. Page 8, you can turn over to page 8. Again, if you're going through this with a client, you're going to want to read every line, but I'm just giving you the things that I think are potential test subjects. Page 8, the deed line down there, this is where you're going to list how the deed is going to be generated. Who's going to be on the deed, which might be different than the purchasers, right? Because if only one spouse is purchasing the property, there might only be one, like if Fabian is buying a house and his wife's not with him to sign the contract, could it just be Fabian on the purchaser line on page 1, correct? But on the deed line on this page, is his wife going to be listed on the deed? Yes, because she has to be, correct? So this is how the property is going to be deeded. So every owner who's going to have an interest should be listed on this line. And again, you should indicate marital status here. How about if they're unmarried, should you also indicate something else? As tenants in common or as joint tenants with the right of survivorship? Don't you have to tell somebody how they're going to take title? Okay, now, are you supposed to give them advice on how they take title? No. Just because you write it on here doesn't mean you advise them on how to do it. Where should that advice come from? An attorney.
So an attorney would basically tell them that it's okay for us
To write this on here, exactly. So generally speaking, you'd only want to have them talk to an attorney about that if there are two unmarried people purchasing property. Obviously, if they're married, you know what it's going to be.
Right.
And you don't have to say as tenants by the entirety, because if you just put married there,
That's what
it's what it means. That's why you put married. But when you put unmarried, it leaves open the question, are they going to be joint tenants or are they going to be tenants in common? You shouldn't give them that advice. You should just simply say, here's the closing attorney's email, phone number, or even email the closing attorney for them and copy them on the email. It says, hey, you know, I've got John and Tammy here who are buying a house together. They're dating, but they're not yet married. Can you give them advice on what the best way to take title is? And you know what the answer is when it comes back, right? But just because you know it doesn't mean you don't have to cover yourself by asking. We all know that the answer is going to come back as what? Joint tenants with the right of survivorship. But let the attorney give them that advice. Okay? Agreement to pay buyer expenses. How many of you have ever heard of seller paid closing costs? You ever heard that expression, seller paid closing costs? So this would be the seller is paying some of the buyer's closing costs. They would go on that line right here. Here's what I'll tell you about that, folks. There's really no such thing as seller paid closing costs. The seller doesn't care what number's on this line, because the seller's simply going to deduct whatever's on this line from the number that's on page 1. If you're paying the seller $200,000 and asking them to pay $5,000 in seller paid closing costs, what are you really offering them for the property? $195. That's the number they care about. So why does the buyer do it?
We don't have enough cash.
They don't have enough cash. And so, if I offer $200,000 with $5,000 in seller paid closing costs, it allows me to borrow the money because I'm paying $200,000 for the property, so my loan is based on a purchase price of $200,000 instead of $195. So then I can use that $5,000 credit coming back from the seller to cover my closing costs. Does that make sense for everybody?
Yeah.
The seller doesn't care. It's a net number to them. They would just assume it's, in fact, they'd probably rather accept $195 and zero here, because then they're only paying commission on what? $195, whereas if you offer $200 with $5,000 in seller paid closing costs, they're paying commission on the full $200. It's not much of a difference, but it is somewhat. I told somebody one time, I was like, I should just make it $1 million with $800,000 in seller paid expenses, because that would work out much better for me, right? Than $200,000. I don't think that would work. Okay, page 9. Let's see what else we need to point on here. Paragraph 9. We haven't done prorations yet, but we're about to pretty soon. A proration is a splitting of expenses. When you buy and sell real estate, there are certain expenses that go along with the property that have to be split up between the buyer and the seller, like the property taxes, for example. Does that make sense? Mm-hmm. That the seller's going to owe for some portion of the year, and the buyer's going to owe for the remainder of the year. The seller's going to owe for what portion of the year? From January 1 through closing day, and the buyer's going to owe from the day after closing through end of the year, right? That's called a proration when you split. And so the contract outlines these are the things that are going to be prorated between the buyer and the seller. So the taxes, look at that, look at line C though. What else? Rent. If the property is leased, rent was probably paid at the beginning of the month to who? To the seller, right? Well, if we're closing in the middle of the month, isn't some of that rent owed to the buyer of the property? So we would have to prorate out that rent between the buyer and the seller as well. Homeowners association dues. If you close in the middle of the month and the dues are paid monthly, you gotta prorate out because the seller has probably paid for the whole month, so the buyer owes some of that back. Does that make sense? So it outlines the things that we're gonna prorate between the two parties here. Believe it or not, we have to prorate the damn gas in the tank. If there's a propane tank out there, no kidding, we're supposed to have the gas company come out and pump the gas out, measure it, put it back in, and then the buyer pays the seller for the gas in the tank at the rate. Oh my God. I've always told my sellers, forget it. We ain't doing all that. It ain't worth it. You know, unless you got like a 10,000 gallon tank out there, we're not doing that. It's too much work. Because the gas company's going to charge like $150 to come out and do that. You know, so they're going to charge us $150 to prorate $200 worth of gas. What did we just accomplish? You know, nothing other than costing the buyer money. That's it. Okay? Paragraph 13 is an important one. And we're almost done. I'll let you go to lunch. Okay? Paragraph 13 is super important. Remember I said that the closing date on this contract doesn't say time is of the essence. So that means the closing date is just what? It's a target. It's not a firm date, right? Well, let's talk about just how much of a not firm date it is. This paragraph deals with what if we have a delay. Here's what it says. You got 14 days. It says, absent agreement to the contrary, if a party is unable to complete settlement by the settlement date, but intends to complete the transaction and is acting in good faith, and if the other party is ready, willing, and able to complete settlement, then the delaying party shall give as much notice as possible to the non-delaying party and the closing attorney, and shall be entitled to a delay in settlement. It says shall be entitled. Does it say shall have to ask?
Nope.
No, it says he's yours. You're entitled to it. So the delaying party is entitled to a delay. If the parties fail to complete settlement and closing within 14 days of the settlement date, or otherwise extend it by written agreement, then the delaying party shall be in breach. So you're not in breach until you've missed the closing date by how long?
14.
14 days. You think that's important when you present a closing date to a buyer and seller?
Yes.
If you don't, folks, they're going to have all their crap on a truck 2 days before closing. And now you just found out that the sellers can't move out for another 10 days. Is your buyer going to be upset at you? Exceedingly. Is there anything you can do about it? Nope. So when you present that closing date to the buyer, you say, don't make any firm plans within this 2-week period because they've got that long and there's nothing we can do about it. Even if the day before they said, yep, we're ready to go tomorrow, and then they got sick that night and couldn't move their stuff out. And so they call you and say, well, the next day the movers have is 10 days from now. Do you have to deal with it? Yep, because they're not in breach. Right? Is everybody okay with that? Understand it? It's a big one. Big one. Those closing dates are not meant to be firm dates. Over on the next page, there is a whole list of standard addenda that can be attached to this thing. What are the first 3 letters in that word addenda? Add. So addenda, which is just the plural of the word addendum, addenda are additions to this contract. So if you read through this whole contract and you think, man, you know, it really doesn't talk about this thing that I'd like it to talk about, there's a whole set of other forms that you can look for. So for example, if your buyer was getting an FHA loan, is there a form on here that looks like it might apply to that situation?
Yes.
Maybe the FHA VA finance addendum. This is not rocket science, by the way. You know, and so if your buyer was getting an FHA loan, you would want to include the FHA VA finance addendum. Here's a test question for you. If you have read through the standard offer to purchase contract and the standard addenda, and some concern of the buyer or seller is not addressed in those documents, what should you do? Have an attorney draft an addendum specifically for what you want to have accomplished. You see this line down here? this blank line that's there, that is not for you to say something that was not said in one of those forms. It says, identify other attorney or party drafted addenda. So the only reason you use that line is if there's going to be another addendum that you're including, right? And if that addendum was drafted by who?
The attorney.
An attorney or one of the two parties, the buyer or the seller. Not Travis Everett Real Estate Broker. I'm not allowed to do that. Is everybody okay with that? That's it. That is the high spots of the contract. Page 11 is the signature page where everybody's going to sign. Page 12 is where you're going to put your information, the firm's names that represent each client, and how, notice you have to put on here what type of agency relationship you have with those clients. You see, does everybody see where I'm looking? Like the selling agent notice address down there. It says firm name, and what is the firm acting as? Are they the buyer's agent? Are they the what? Seller sub-agent. So what would that mean? If you saw selling firm here, and it checks seller sub-agent, what does that mean about the buyer? They are what? They are unrepresented. So presumably the firm name on the left side would be the same as the firm name on the right side in that case. What's the other reason the firm name on the left and the firm name on the right would be the same? If they were dual agents. If they were dual agents. So if the firm name on the left and the firm name on the right are different, that is most likely a what kind of transaction? A co-brokered transaction. Does that make sense for everybody?
How come it doesn't have buyer sub-agent?
Because that would just be buyer's agent. We don't use terminology buyer sub-agent.
If the seller's unrepresented?
If the seller's unrepresented, you just be a buyer's agent.
Oh.
Just be a buyer's agent. I'm not saying buyer sub-agent is incorrect. I'm just saying it's not used terminology. It's not terminology that you would find that anybody would use. They would just say, well, I'm a buyer's agent.
So if it's both the right side would only have the seller notice filled out and nothing else.
That's exactly right. So on a FSBO, you wouldn't see anything on the listing agent there, because there is no listing agent. You would simply have one firm on the left-hand side.
That would be like for sale by owner.
For sale by owner.
But then they cannot use this form because they're
Sure
not.
they can. The buyer's agent is a what? Is a realtor.
Oh.
It's not necessary that everybody be realtors. It's necessary that there be a realtor involved in the transaction.
Oh.
What would not be allowed is if you looked at this form and there's nobody listed down here, and let's say if it's just a buyer and a seller, that would not fly. In fact, closing attorneys are not supposed to close them like that. They do, but they're not supposed to, because they're enabling theft at that point in time of the form. And by the way, you can, as a licensee, buy these forms and not be a realtor. They will sell them to you separately. Interestingly, they will sell them to you for exactly the cost of joining the Association of Realtors. I find that to be the most hilarious thing in the world.
Wow.
No, you don't have to join. We'll sell them to you separately. What does it cost to get the form? Same thing it costs to join. Alright, how do you feel about that contract? That's a lot to take in, right? But it's a fairly straightforward contract. For being as long as it is, it's not too terribly, out there and hard to understand, I don't think, anyway. Did y'all agree with that? Okay. Are you clear on this idea of due diligence? Because that is ultra important in that contract. Is everybody good with that? Good. All right, so let's take a break, and we'll come back and dig a little deeper into this chapter and finish it up. Okay, come back at 1:30.